All kinds of unfortunate things can happen beyond our control to put normal life on hold. When the worst happens for someone along the competitive and demanding path to becoming a lawyer, it can put them at a serious disadvantage when applying for a training contract or pupillage. This is why it's so important to inform employers and universities when you have genuine mitigating circumstances that have affected your academic performance. It can be difficult and uncomfortable to tell recruiters about something so personal, but it's important to put your application in context and give yourself the best possible chance of success. Firstly, check out the website of the firm or chambers that you are interested in applying to and find out the best way to display your extenuating circumstances on the application form. If you can't find this information on the website, it is perfectly acceptable to call or email the recruitment team to ask them directly. Recruiters are usually happy to field any queries about the application process, so don't feel afraid to contact them. Many firms and chambers provide sections in the application forms for detailing any extenuating circumstances that have impacted a candidate's grades. When disclosing your extenuating circumstances, the key is to stay professional and matter of fact. You don't have to disclose every detail. Make sure you link what happened to how it affected your academic performance or ability to work. And do make sure that your circumstances are genuine. We've all heard stories of students using bizarre and unbelievable tales to explain away their bad grades. You may also need to provide some sort of verification of what has happened in the form of a doctor's letter or a supporting note from your school or university. Recruiters might ask for this after you submit your application, so have this to hand. And it's always worth saying on the application form that you have the evidence available upon request. You should be prepared for reactions to differ from employer to employer. Some might not be very interested, but others will try and help you as far as they can. If you have a bad experience disclosing a mitigating circumstance to an employer, it's probably a good sign that you wouldn't want to work there anyway. It's also a good idea to demonstrate that in otherwise normal circumstances, you can achieve good grades and be the kind of person that a law firm wants to hire. Recruiters will still want to see you demonstrating all of the key skills that define a good lawyer, so keep that in mind. Your mitigating circumstances should hopefully be a small part of an otherwise good application. If you are particularly worried about disclosing mental health issues as a mitigating circumstance on a law firm application, check out the LCN Says article that will be linked in the description. And don't forget to head to Law Careers Net for more application information and advice.